Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I am very pleased and honored to speak with Suzanne Natbony, a partner at Alliant LLP with her own firm in Los Angeles, Solve and Win. She is a business transactions attorney, primarily outside general counsel for her business clients, with most in the healthcare industry. Suzanne, welcome. Thank you for being on board today.
Thank you, Michael. It's nice to be here.
We were introduced, I believe, through Dr. John Weatherspoon, and we've been in communication since. Why don't you tell the audience a little bit about yourself?
Sure. I'm a California lawyer. I've been practicing since 2009 and I'm in Los Angeles and I practice, like you said, business transactions. So I'm sort of corporate counsel for a number of different businesses, mostly in healthcare, a lot of medical practices, medical spas, and some in other industries like tech and entertainment and real estate. So I love what I do. And yeah, Dr. John Weatherspoon introduced us. He's my patent attorney. I'm also an entrepreneur. I have several patents on a medical device and in the legal tech industry as well. And so we've been working together for my company, on my companies, and then on client matters as well for like 15 years, 10 years. So yeah, it's great to be introduced to you. And you do intellectual property. You're on the East Coast. And
Well, they say the right coast, or you're on the left coast, or whichever way, depending on which hand we are at. Uh,
right, exactly.
okay, so today we're going to be talking about side hustles and protecting and monetizing your IP for side hustles. So let's get started. I think one of the first issues you need to understand is the employment restrictions, because we're talking about side hustles. You're working for someone else. What do you need to be worried about?
Yeah, so I thought this topic was interesting because one of my friends and clients is a doctor and he works for a hospital and he has a side hustle and he wants to know what he can do with the intellectual property that he develops. And so, the first thing he has to do is review his employment contract because it probably has a lot of restrictions in it. And in California, we do have a safe harbor for employees, though, because as long as it doesn't interfere with the employment, employees should be able to do things on their own time. But employers may have a moonlighting policy and want to vet any kind of companies where an employee could work for that could be in direct competition in which the employee is violating the non-disclosure and intellectual property assignment agreement. So that's something big to look at for any employees looking to start their side hustle, is to first go to your company documents that you already have and review those with an attorney and see what you can do. Right? Is that what you would say, Michael?
Uh, Sounds great. I mean, I guess there's going to be one is there's going to be some instances where you have no employment contract. And then I know, or I believe, that California is more employee friendly, because I know they don't have non-compete clauses. They're going to be more employee friendly than some other states, and this is governed by state law. So you would need to check depending upon the state. Like, have you worked with clients outside of California?
I have clients that are outside of California, but they're businesses that expand to other states. I'm not working for employees outside of California.
Okay.
So, yeah.
And then, I mean, I guess the issue is, does your employment relate to what you're doing? And I guess that can be a questionable area.
Yeah, that's usually the issue, though, is usually, the doctor is trying to, let's say, do a medical spa in the spare time. And they're a doctor and they're working for an institution or hospital, or they have a medical device idea. So I mean, if they're doing something completely different, like, if they were coming up with a tennis brand and they have tennis attire that they had designed, and which I know somebody did that and her free time, then that wouldn't likely interfere if you were a medical practitioner, shouldn't interfere, as long as you're not stealing the, let's say, client lists and trying to market to those patients or clients of the practice or business. So, um, yeah, California does basically prohibit non-competes, but there are some exceptions to that. So you can still have non-competes hold up if you're an owner of a business and you sell, which can happen when, let's say, you're, an employee and you're also an owner, and then the business gets sold and you sign a non-compete. Well, that will probably hold up as long as it's not overly onerous. So there are some exceptions.
And you're thinking about doing your side hustle. You've got this idea, you want to move forward. Do you ask first the employer? Do you not ask? What are some of the factors to consider in that regard?
Yeah, asking for permission versus asking for forgiveness.
Better said than I just said it.
Yeah, I mean, so it's a fact dependent situation where you would want to, it's based on the client's risk assessment and risk tolerance. Sometimes, I've advised clients to run this by the team that you work for, and they just decide, no, I don't want to deal with it. I'm just gonna back off. But, certainly it's a possibility that they could get clearance from it. And if they don't, and it's completely unrelated, then having a lawyer, get involved or copying the attorney. But some clients prefer to take the risk and say, I'm just going to work on the side and not ask. And we go over the potential, risks of doing that, pitfalls of getting caught in litigation and suing. And so it's based on, what they're doing, what their culture is like at the company, who they work with, and how important it is to them.
I would assume there's kind of two big no-nos if you're going to be doing the side hustle. One is don't be doing it during your work time.
Exactly.
And then the other biggie is don't be using company resources like I would say even probably your laptop or equipment or going into the office and using it, unless then you better have some pretty explicit consent in that regard. Otherwise, you very quickly get into the area of they at least own at least part of it, correct?
Yeah, it's possible, but like we talked about in the beginning, in California, it's very employee friendly in the court system. And so burdens on the employer. And
Okay. All right.
and that's the thing, is that you end up with these disputes. Well, if the employer tries to sue me for this, I'm going to counter sue for that. And so it's sometimes not worth it for the employer to proceed.
All right. Sounds good. Sounds like if I'm going to be doing this, I should move to California. Uh, okay.
Well, yeah, I don't know if did you when you did your LSAT prep course,
Oh
did
boy.
you, I know, right. For me, it was a long time ago too, but I took Test Masters, and that was a big case. Test Masters was had Blueprint test prep. They sued Blueprint. It was kind of an offshoot of the instructors from Test Masters, and it was, I think, it was sort of ended up being a wash. Test Masters sued Blueprint for taking IP, developing all these course materials based on what Test Masters had, and they sued for millions and millions of dollars, and they did win, but they won probably not enough to cover their legal fees.
Yeah.
So
All right.
yeah, that's what and it was pretty egregious the way. I remember I actually had this instructor who was allegedly stealing materials. And I saw the deposition because it was posted online and may still be online. And I was like, wow, looks like they stole some materials. But they not really much of a slap on the hand because the business wasn't enjoined from, further operating
Okay.
or anything like that.
All right. So maybe you ask for forgiveness later and see what happens.
Yeah.
Uh, protecting. So let's say you've got your side hustle and you want to pitch it. What are some things you should have in place to protect yourself?
Well, certainly having a non-disclosure agreement that talks about, what you're trying to develop and protect. And and, the term on it and how to resolve any disputes. And that should be properly drafted. There's some pretty bad NDAs, and maybe it needs to be mutual or it could be unilateral, but that's important. And just, having documentation over developing it on the side, making sure that you have your own laptop and that you, have taken steps to protect your intellectual property. If you're maybe designing something, you have obtained a copyright or, seeking out counsel for maybe patent protection.
Like a provisional application. I guess going to the documenting, I mean, if you put dates, I did this on so and so date, and you have timestamps, I guess that's pretty good evidence of establishing like you're the one who invented this, or you're the one who developed this, or you're the one who did this before somebody else.
Yes, that would be helpful. Right now, actually, one of my clients is a third-party witness in one of these cases. And so the company is trying to determine if the employee used company resources to solicit my client. And we got the subpoena, and I had to review all the emails, and I'm like, I don't see anything in here. So employee wasn't trying to solicit my client or steal. It didn't show anything about stealing company materials and using it with my client separately, besides for the business he worked for. So we'll see how that case comes out.
All right. And with respect to NDAs, I'm guessing you can't just feel 100% comfortable that someone's not going to take what you have anyway. And so you have to do whatever you can to prepare yourself and to do some of these other things like the intellectual property and the documentation, because if people want to steal, especially like a bigger company, they're going to do it anyway, potentially.
Yes, I've dealt with that as well. That's why I have several patents. And, I did talk to somebody once who was like patent schmatent. And if somebody really wants to rip you off, then they're just going to develop something on the side, around it. But it does help to have that patent or have filed a provisional patent. And as far as NDAs, I've actually been in some very contentious NDA negotiations where it's like, they want me to make so many changes as the inventor and a business owner that what is the point of even signing this? And then the deal falls apart because we can't get an NDA in place. And so because of my concern that they're just trying to find out information about my development and what I'm doing, and they're not going to really, acquire my IP. So it's very challenging.
I think at the end of the day, I mean, any deal's about trust, right? And if you're going through all these back and forths just for the NDA, how much trust truly is there?
Right, exactly.
All right, so this is the end of part one of speaking with Suzanne Natbony about side hustles and what you can do to protect yourself and issues to consider. In part two, we're going to be talking about the structures for monetizing and planning for conflict. So Suzanne, thank you. For everyone, please thank you for tuning in, and stay tuned for part two of our discussion with Suzanne.
Thank you, Michael.